Right now, last time we have discussed about the incorporation of the company. Today we can move to our second topic. These articles of association. Right now, as we discussed, in order to incorporate a company after the companies that they have to submit some documents. What are the documents to be submitted? Question. Yes. What are the documents to be submitted to register? Index proposal 16A, articles of association, application form 1, other document, right? Right. So, one document is articles of association. Right. So, this is the constitution of the company. We can treat it as the constitution. Right. So, the applicant has to submit a copy of articles of association to register company. Go to incorporate it under the company. So here, actually, we have discussed there are three options given. One is the company can prepare its own set of articles, like new articles of association, right? Then the second option is company can adopt the model set of articles sent out in the first schedule to the company side. Model set. Model set of articles set out in the first schedule. So it is returned in the first schedule to the company side. First schedule to the company side. Right? Company can adopt the model set of articles. They need to submit a copy of the articles of association. Company has to just mention they are adapting the model set of articles as right. They are articles of association. Right. Then another option given, that is the third option, that is the company can change the model set of articles. Right. Alter the model set of articles and adapt. Right. Alter the model set of articles and adapt. So there are three options too. Company can prepare its own set of articles, new one, brand new one. Second one is company can adopt the model set of articles, and the third option is alter the model set of articles and adapt it. There are three options we can recognize in terms of articles of association. Now, when we consider the articles of association, very important section is section 30 of the company's stand. Section 30. How we can open new case. Right, just again. Now, section 30. Section 13 of the Companies Act is related to articles of association of the company. So, section 13 says the company may, that is the word, may set out, right? May set out objects of the company and rights and obligations of the shareholders, right? Provisions with regard to management and administration. Any provision not violating the Companies Act. Not violating the Companies Act. Right? The company may set out in its articles of association objects of the company. Objects of the company. Rights and obligations of the shareholders. Rights, obligations, privileges of the shareholders. And provisions with regard to management and administration. That's all. Very wide scope introduced. Any provision on the condition is not violating the Companies Act. The company can mention these particulars in the articles of association. Now, this word is very important. May. Right? If it says shall, what is the difference between these two? If it says company shall mention its objects, rights, and obligations of the shareholders and provisions with regard to management. It says shall. Right. So here it says may set up. Yes, what is the difference? Shall is compulsory. Shall is compulsory. Therefore, here it says may set out. Therefore, company can mention its objects and these particulars in the right articles of association or avoid from mentioning these in the articles of association. This is not a compulsory requirement. Understood? Right? So very important. important points. May set out objects. May set out objects in the objects. Right, and there are some other solutions like objects, rights and obligations. Like management solutions with regard to management and activities. Like that, these processes may be included in the articles of association. Please set out. For company need not to mention its objects. Only rights and obligations of the shareholders can be mentioned. Like, right? Objects as well as rights and obligations, provisions with regard to management, they can choose. Likewise, they have very wide choice with regard to mentioning these particulars in the articles of association. Now, when we consider the legal effects of the provisions mentioned in the articles, right? Suppose like suppose like this. And now there's a company called ABC. ABC. ABC private limited. Objects of the company. Now, these are the articles of association of company. Articles of association. AOA and articles of association. It says object of the company is manufacturing goods. Object is manufacturing and selling goods. That is the object of the company. Then, thereafter, says yes. Then further it says rights and obligations of the shareholders can be mentioned in the article. Therefore, in this article, it says every shareholder is entitled to cast one vote per share. Every shareholder is entitled to cast one vote per share. Right? Another provision. And further, it says every shareholder has preemptive right over the preemptive right. Preemptive rights. Every shareholder has a preemptive right over the shares of other shareholders. Other shares. the share. I will come to this preemptive rights. Right? Preemptive right over the other shareholders of the company. Preemptive right over the right shares of the other shareholders. Right, then management and administration, provisions with regard to management and administration. Therefore, now in this company, ABC Limited says every director, right, every director is entitled to receive, right, 100,000 rupees, right, per month. As remuneration, right? Monthly salary. Every director is entitled to receive monthly salary of 100,000 rupees per month. Right? Another provision mentioned in the article. And like we can consider this, right? Some other provisions may be included in the articles. Right? Now, very important concept, that is right now there are 4 provisions in this article. One is every shareholder is entitled to cast one vote per share. Right? Every shareholder has preemptive right over the shares of the other shareholders. Right? Every director, it is related to directors. Every director is entitled to receive 100,000 rupees salary per month. Right? So these are the provisions contained in the article. Right? Now, another provision we can include That is so by right, legal officer of the company, right? Legal officer of the company is entitled to receive 100,000 rupees per right, legal officer or accountant or whatever, right? Can be some for that entitled to receive 100,000 rupees. Right. Now, when we consider these provisions, right? Some provisions are related to shareholders. Right? Some provisions are related to shareholders. Some are not related to shareholders. So first we have to consider whether the provision is related to his capacity as a shareholder. His capacity as a shareholder means by being a shareholder of this company, AG Private Limited, by being a shareholder of this company, this right or privilege is given to that person. Right? By being a shareholder, this right is given to them. Right? So we have to consider whether the provision is related to his capacity as a shareholder or not. It's simple. Yes. Right? Now, when we consider the first one, it is regarding to the objects of the company. Therefore, it is not related to shareholder. But when we consider the second provision, right? That is, every shareholder is entitled to cast 1 vote per share. It is related to his capacity as a shareholder. It is related to his capacity as a shareholder. This one, second one. Because by being a shareholder of this company, this right is given to this person. Right? By being a shareholder, he is entitled to cast 1 vote per share. Therefore, suppose a particular shareholder he owns, right, 100 shares, then he is entitled to cast 100 votes. Because of the provision mentioned in the articles of association. That right is given to shareholder. And the third one, preemptive right. Right? Preemptive right. Every shareholder has a preemptive right over the shares of the other shareholders. Right? That is also related to shareholders. Right? It is related to shareholders. By being a shareholder of this company, this right is given to this person. Right? Preemptive right means preemptive right. Preemptive right. Preemptive right means, right, now suppose A is a owner of a property. It may be a land, right? Land or right, any property, share or whatever, right? A is a owner of a property. Right? Right. There's another person called B. Another person. Right? Suppose this is a land. He is the owner of a land. Right? If B has a preemptive right over the property of A, right? Actually, this right is if A goes to sell this land, right? The first choice to be given to B to purchase the land. First choice to be given to B. If B refuses to purchase the land, then A can sell it to outside party. third party. See. Understood. So here we can identify B has a preemptive right over the property of A. Preemptive right. The right is given to B to purchase the property. The first choice to be given to B. Right? If B refuses, then A can sell it to outside. Understood? So this right is named as preemptive right. Right now, suppose this is a ready phase. He is the owner. He is the undergoing. Cultivator. Now, suppose the owner of the benefit is going to sell the land. The land means marshy land, right? Then the first choice to be given to the cultivator. If the cultivator refuses to purchase the land, then owner can sell it to another part. Right. So we can identify cultivator as the preemptive right over the property of right A, owner of the land. Right. Another one, actually, another preemptive right we can recognize in law of Tesala. Law of Tesala. What is it? Law of Tesala, this is applies to areas, right? Yeah, according to the law of Tesala, this regarding to the properties. Right? Suppose the owners of a property, again land, owners, suppose A and B, they are owners of a land. It means half share owned by A and half share owned by owners of a property. According to law of Tesala here, right? Then if A wants to sell his undivided shares, right? The first choice to be given to the existing co-owners. First choice to be given to the existing share co-owners. If they refuse to purchase, the undivided share, then they can sell it to outside party. Right. Again, we can recognize this preemptive right. So, co-owners of undivided property, they have the preemptive right over the shares of the other co-owners. Co-owners, according to the law of this right. Right. Why actually this type of right is given to the right B or the other co-owners? Right. What is the reason? Yes. ඇයි එහෙම දෙන්නේ මේ ඒගොල්ලන්ටම ගන්න. ඕන කියන්නේ කවුලේ ඉන්න අර්ථු ඒගොල්ලන්ටම මේක මිලදී ගන්න අවස්ථාවක්. ඇයි? එමයි කියන්නේ මේ තවලෝ කියන ප්‍රශ්න අහන්න. අහන්න. ඇයි අලුතෙන් කට්ටිය එනකොට ඒගොල්ලෝ අතරම නේ a newcomer, right? Then it may be an issue to the entire land, right? It may be an issue to the other co-owners. Therefore, the first choice to be given to the existing co-owners. And so, same concept we can identify in concurrence. Right? That is named as preemptive right over the shares of the other shareholder. Therefore, suppose A is a shareholder of the company. Right? Shareholder of the company. Is the owner of the shares. Then if A wants to sell his shares, first choice to be given to the existing shareholders. Existing shareholders. First choice to be given to the existing shareholders. First choice to be given to the existing shareholders of the company. If the existing shareholders refuse to purchase, he can sell this to outside party. Understood? So this is the preemptive right. So by being a shareholder of this company, this right is given to him. Right? He must be given the preference or the choice to purchase the shares if a shareholder is going to sell his shares. Right? This is named as pre-emptive right. Actually, according to section 53 of the Companies Act, this pre-emptive right is recognized. Is that right? It is recognized in the Companies Act, right? So this right, actually it's a right to the existing shareholders. This right is given to the existing shareholders, right? To purchase shares of the, right? Shares of the that shareholder who is going to sell the shares, right? So preemptive right over the right other shareholders of the company. So here, again we can identify the third provision. It is also related to this capacity as a shareholder. Well, right. But when we consider the fourth provision, fourth one, every director is entitled to receive 100,000 remuneration per month, salary per month. It is related to his capacity as a director, right? As a shareholder. Therefore, it is not related to his capacity as a shareholder. It is not related to his capacity as a shareholder. Not related to his capacity as a shareholder. And the last one is legal loss. Entitled to receive 100,000 rupees per month. Again, we can identify it is not related to his capacity as a shareholder. Understood. First, we have to select what are the provisions related to his capacity as a shareholder. Understood. Very important thing is if that the provision is related to his capacity as a shareholder, right? By that provision, a binding contract made. Contract. Binding contract made. Binding contract. Contract made between right shareholder, right, between shareholders and the company or the shareholder, single shareholder, and the other shareholders of the company. Shareholders of the company. Binding contract. Binding contract between the shareholder and the company or the shareholder, single shareholder, and other shareholders of the company. Contract 4, right? Binding contract. Right. So if the provision is related to his capacity as a shareholder, binding contract made between, actually there are two types of contracts. One is made between shareholder and the company. Shareholder and the company. Or, right, another contract may be for between shareholder, single shareholder, and the other shareholder. Understood? The only thing is, first we have to consider whether the provision is related to his capacity as a shareholder. By that provision, right, automatically, binding contract with right, shareholder and the company, or single shareholder and the other shareholders of the fund. Now, suppose like this, it means, now according to my second provision, it says every shareholder is entitled to cast one vote per share. Suppose A is a shareholder of the company. A is the shareholder of the company. A holds 100 shares. A holds 100 shares. Right? 100 shares. 100 shares. Right? Then, therefore, according to the provision, he is entitled to cast 100 votes. Right? In a particular general meeting, the chairman of the meeting refused to admit these 100 votes. Then, this shareholder A can file an action against the company on the basis of breach of contract. Right? In order to recover damages. Right? He can file an action. The shareholder can file an action against the company on the basis of breach of contract. It will mean right? Because by this provision, a binding contract made between the shareholder and the company. If the company has violated, then the shareholder is entitled to damages. And on the basis of breach of contract. Understood? So here is the right. Contract between shareholder and the company. And the second one, in my solution, I told, right, every shareholder has preemptive right over the shares of the other shareholders. Right now, suppose A, the shareholder, right, A holds 100 shares. Right? However, without giving, right, the choice to the existing shareholders, and they are E and C. Right? Without giving the choice to the existing shareholders, this shareholder A is sold his shares to another party called X. Then existing shareholders B and C, they can file an action against A in order to recover damages on the basis of breach of contract. Right? Between themselves and each. Understood? So there are two types of contracts. If there is a breach of contract, then the aggrieved party, innocent party, right? They can bring an action on the basis of breach of contract. When violation, they can bring an action for so automatically binding contract means one is shareholder, shareholder and the company. The second type of contract is between single shareholder and other shareholders and the company. Right? So if any violation, in order to recover damages, right, aggrieved party or innocent party can bring an action. Right? So, like on the basis of so these are the legal effect of provisions contained within articles. First, we have to consider whether it is related to his capacity as shareholder. By being a shareholder of the company, his right is given to this person. Then it is related to his capacity as shareholder. Then binding contract. Any violation, there's a party can bring an action for damages on the basis of understood. But when we consider the fourth provision, it is related to his capacity as a director. If the director is entitled to receive 100,000 remuneration, it is related to his capacity as a director. No binding contract made by that provision. No binding contract. And the final one, it is also related to his capacity as a legal officer. Therefore, it is not related to his capacity as a shareholder. No binding contract made by that provision. Understand? only by the provisions which are related to his capacity as a shareholder by the contract. Right? By the contract. Now, Articles of association, it says every director is entitled to receive 100,000 rupees per month as remuneration. The company is ABC and ABC Private Limited. Your brother, right? ABC Private Limited. Private Limited. Then what? In the articles of association, it says every director is entitled to receive 100,000 remuneration per month. Then, Mr. Pereira, he became a director of his company. He became a director of his company. He, right, was appointed as a director of the company. In the appointment letter, right, in the appointment letter, suppose this is the appointment letter. He is appointed as a director, but salary payable to this person is not mentioned. Salary is not mentioned in the appointment letter. Right? There is no any provision in the appointment letter with regard to salary payable to this person. So if the appointment is made by an appointment letter, right? So it is in writing, no? It is in writing. Is it right? According to the appointment, salary payable is not mentioned. Then what happened? After he appointed as a director of this company has attempted to pay him lesser amount than 100,000 rupees. Suppose the company is going to pay Mr. Pereira 75,000 rupees. 75,000 rupees per month. Right. Now the issue is, can Mr. Pereira, issue is, what is the amount to be paid to Mr. Pereira as remuneration? 75,000 no, 100,000. Yes. Can Mr. Pereira, right, pay 100,000 rupees as his remuneration? Can no harm. Yes. Can no harm. Based on this provision, can he claim 100,000? Can he argue? Right? According to the articles, it says 100,000. Therefore, I am entitled to receive 100,000. Likewise, can he argue? He can't argue. Not hard. Why? By this provision, no contract. Between Mr. Pereira and if the company and Mr. Pereira, no contract. And therefore, he cannot say because of the articles of this is the fundamental law in the company. It's a constitution. It is treated as the constitution. Even though it is a constitution, Mr. Pereira can't argue. The article says 100,000, therefore I am entitled to receive 100,000. Cannot say, cannot argue. Reason is because it is not related to his capacity as a shareholder. It is related to his capacity as a director. Therefore, by this provision, no contract. But shareholders can argue. You can argue. Right? Article says this. Therefore, the company cannot violate that. It's a breach of contract. If it is related to his capacity as a shareholder. Understood. Therefore, actually here, Mr. Pereira cannot argue, right? On this provision mentioned in the articles, he is entitled for 100,000 rupees. He cannot argue. But only thing is, right? In a particular case, what happened, the same incident, article says 100,000, right? There is the salary payable to directors. When a person is appointed as a director, rely on this provision. According to the appointment letter, salary payable is not mentioned. Not mentioned. Then what happened? The company attempted to pay lesser amount, then this person filed an action against the company. He also recover 100,000 rupees instead of 75,000. Right? If I have action in order to recover the amount mentioned in the articles. Right. Then all shares by this provision, no contract. No contract. Right? But right. Now in a contract we can identify there are two types of terms. There are two types of terms. Yes. There are two types of terms. We can divide it into right? Express. Express that implied terms. Express term, implied terms. There are two types of terms. Right? What is the meaning of express terms? Yes, express terms. Express terms means terms agreed by the parties implied in no order. Terms agreed by the parties implied in no order. They are being as express terms. Right. Now, according to the appointment letter that is in writing, no salary payable mentioned. There is no any provision with regard to salary payable. Right. Then in this case, what do you mean by implied terms? Implied means parties can imply or attribute some terms in order. We can imply some terms in the contract in order to understand the nature of the contract. Right? Parties can imply some terms in the contract. Right? They need not to expressly mention. Expressly means you write it over. The material. Express and imply. Sorry. Yes, there are two types of terms, express terms and imply. Express means terms agreed by the parties implied in the only. Implied means we can imply some terms into the contract in order to understand the nature or intention of the parties. Right. So in this case, what else? If the salary payable is not mentioned in the appointment letter, it is not agreed by the parties expression. Right? By the provisions by the provision mentioned in the articles, no binding contract form. But right, what is right? Parties can imply the provisions mentioned in the articles of association. So this contract made between Mr. Pereira and right? Parties can imply, Mr. Pereira can imply. By this provision, no binding contract form, but Mr. Pereira can imply this provision to his appointment letter. Therefore, right, the provision mentioned in the articles to be treated as an implied term of this contract. Between Mr. Pereira and this director. Therefore, court held, right, company cannot pay him lesser amount. Company cannot pay 75,000. Right? So this provision can be implied into the agreement because it is not expressly agreed by the parties. Therefore, Mr. Pereira can imply salary payable mentioned in the articles to this agreement. Appointment letter. Right. Therefore, it to be figured as an implied term. The company cannot pay him lesser amount. Understood? Therefore, maybe an implied term. Now, when we consider the provisions, right? When we consider the provisions which are related to directors, lawyer, accountant, secretary, or whatever the other parts, other than shareholders, right? Those provisions may be treated as implied terms. Right? By those terms, no binding contract form between company and that person. Between the company and that person. That person is director. Company and director. No binding terms. Company and secretary. Company and legal officer. So, no binding contract form. But like these provisions can be treated as a implied term. This only an implied term. No binding contract. Right? Understood. So if it is valid, only thing is we have first consider whether the provision is related to his capacity as shareholder. It is related to his capacity, binding contract form. So there are two types of binding. One is made between company and shareholder. And the second type of contract will be made between single shareholder and other shareholders of the company. That is the binding contract. So if the provisions are related to his capacity as a right director, lawyer, accountant, right, secretary, whatever, right, auditor, whatever the other person other than shareholder, no binding contract form. Actually, no binding contract form, but binding contract form in company and that person. But these provisions can be treated as implied terms of another contract. Maybe that person and the company like this appointment letter. So another contract made between this director and company. So in this contract, that provision contained in the articles can be right, considered as an implied term. And we can attribute that terms into this contract. There is nothing mentioned regarding the salary payable. We can attribute that provisions in the articles to this contract. Like between that person and the company. Take it So that is the legal effect of provisions contained in the articles of association. Right. Therefore, we can say this can be treated as an in-flight term of another contract between company and direction. Right. This one, an in-flight term. In-flight term, right? Can be a in-flight term of a contract made between company and the direction. This is also same. This can be treated as an implied term because it is related to legal also. With regard to shareholder, it can be treated as an implied term of a contract, another contract made between company and legal officer. Company and legal officer engage into another contract. And company and legal officer. Then, this provision can be treated as an implied term. Therefore, if like provision is not mentioned in this agreement and between these two parties, then it can be attributed. These terms can be attributed to. If the appointment letter says like the salary payable is 75,000 rupees, then what is the amount this director is entitled? 75,000 or 100,000. Then 75,000. He cannot ask like 100,000 rupees. He cannot imply because it is expressly mentioned. Salary payable is 75,000. Understand? Right? It is expressly mentioned. There is no express provision, then he can imply. In order to fill the gap, he can imply. Terms mentioned in the article. But if it is specifically mentioned, expressly mentioned, salary payable is 75,000, then he cannot ask 100,000. He cannot imply because it is expressly mentioned. In writing, it is agreed by the party. That is the truth. And expressing terms agreed by the parties in writing or oral. So parties agree. Direct and company both agree. Salary payable as 75,000. There are nothing to imply. It is already expressly agreed by parties. Okay. That is the legal effect of provisions. Fine. Then thereafter we have to consider about the object. Object clause. Object clause. Another very important, right? Object clause. Now, as I mentioned, according to section 30 of the Companies Act, the company may set out its objects. We set out its objects. Set out its objects. In case it is not compulsory, right? The company can mention its objects, or company can avoid from mentioning its objects. Now, according to this example, ABC Private Limited, they are made the object of the company is manufacturing and selling books. Selling books, integrated manufacturing and selling. Then, another very important concept we can identify now, firstly, right? We have started this lesson by considering there are two types of persons. Right? Persons we divided into two. Natural means human, and legal person. So under legal persons, we can recognize companies. There are two types of legal persons. Some are established by an act of the parliament and by registration under the Companies Act. We are discussing about the companies. Right? So the companies incorporated under the Companies Act. Legal persons. Right? One difference between these two, natural and legal person, right? Now, natural person, it is like the capacity to contract. Some persons are not of capacity to contract. Right? Who are not of capacity to contract? Natural persons. Yes. They cannot engage into contracts. Even they are natural persons, they cannot engage into contracts. Minors, yes, minors, they cannot engage into contract. Who is a minor? Below 18 years. They cannot engage into contract. What else? Insane persons, insane persons, intoxicated. They are not of capacity to contract. They cannot take it. So generally, apart from these persons, natural persons, they can engage into any type of contract. Right? Any type of contract. Whatever we say gives some word as long as it is legal, right? They can engage into any type of legal contracts. Legally or but they are not treated as valid. Right? Any type of contract. But when we compare with the legal person, company, that if the object of the company is mentioned as manufacturing and selling goods, right, they can engage into contracts which are permitted by the object. In other words, they cannot engage into any type of contract. That's the limitation. Understood? They cannot engage into contract for manufacturing goods, motor cars, right? For solar panels, whatever, right? Other types of contracts not permitted by the object. Understood? But natural person, there is no, if that person is able to engage into contract, right? This person is of capacity to contract, then he can, no limitations, he can engage into any type of contract. He can engage into contract to purchase a good, right? Or wood, motor car, real estate, whatever, right? Type of contract you can engage. Right? But if it is a company, and in this company, according to the articles, if the objects are mentioned, transactions of the company is limited to X objects. They cannot engage into any type of contracts. They can engage into contracts which are permitted by the object clause. Permitted by the object clause. Understood? So that is very important. Right now, here section 13 says may set out. Why they do it? May set out. May set out. May set out objects. Therefore, the company can mention its objects or avoid from mentioning the objects. If the company avoid, right, mentioning its objects in the articles, then capacity of this company is equal to natural person's capacity. Then they can engage into any type of contract. Understood? If the objects are mentioned, then there's a restriction. There's a restriction. They cannot engage into any type of contracts. So here it says may set out. That is not compulsory. Right? The company need not to mention its objects compulsory. Right? So mandated. Mandated. Compulsory is mandated. Not a mandate. Right? It's not a mandated requirement. Therefore, if the company, right, is not mentioning its objects, then this company can engage into any type of contract as a natural person. Understood? Right. So that is the effect because of this word research. Therefore, we can say according to section 30, company need not to mention its objects in the article. It's not a mandatory requirement. Right? What are the companies can be incorporated on the Companies Act? What are the companies incorporated under the Companies Act? Right. Basically, we can identify private company. Then public company. And companies limited by guarantee. Companies limited by guarantee. Right. Companies limited by guarantee. If it is a company limited by guarantee, in section 34, right? Section 34, it says, if it is a company limited by guarantee, right? It shall, that is the word used, right? It shall mention its objects. Can I help you? Shall. This company shall mention 34, right? The company shall mention its objects. Therefore, it is mandatory requirement. Right? Company shall mention its objects. The reason is now under section 34, register of company may grant the license to the company limited by guarantee. They able to satisfy three conditions. Right? The object of the company is useful subject to community, like promoting art, science, religion. Right? So then, that's the one condition. Right? And according to the articles, the company cannot pay any dividends. Right? Dividends, and all the income are utilized to promote the project. So these three conditions are able to meet. Then the registered company will grant license to the company and be registered as a company, limited liability company, but without addition of the word utility. I will discuss, right? So here, in order to identify the objects of the company, objects of the company limited by the guarantee, company limited by guarantee, the section says shall mention its objects. Therefore, if it is a company limited by guarantee, right, they must mention their objects. Right. Then, when we consider public companies, why we name these companies as public companies? If it is a company limited by guarantee, according to the Companies Act, they shall mention their objects. Right. So now we are going to identify actually to who this may, right, may set out this rule will apply. So if it is a company limited by guarantee, then section 30 does not apply. They shall mention their objects. Right. Section 30 does not apply. Public companies. Why we name these companies as public companies? Yes. Public companies, we can divide into two, listed and unlisted. Altogether, we can say public companies. What is the privilege granted to public companies? Kudu Samana, Inalize Kudaka Samana. Yes, they are listed companies. They can trade their shares on the stock exchange. Right? If it is a listed company, unlisted, they cannot trade their shares on the stock exchange. But they have a special privilege. What is that? That's why we name them as public companies. They can invite the public. They can invite the public to purchase the shares. You can invite the public to purchase the shares. And that's why we name and we are Lanka. Public company, they can invite the public to purchase the shares. Invite. Invite the public. Invite the public to purchase the shares. Right? They can invite. Right? What is the way, how they invite the public to purchase the shares? What is the way? Yeah, come on. Yes, how they invite the public? Companies, first they have to invite. Then applicants, they apply for the shares. Then they are after allotted shares to the applicant. These takes the share. How they invite? By publishing an advertisement in a newspaper. Maybe a newspaper or a magazine, whatever media, right? They publish an advertisement. So this advertisement, the full page, they got came with that, right? Invitation, treat here. So, factor then we must an advertisement. An advertisement. We name this advertisement. If you are technical term to this advertisement, it is named as prospectus. Prospectus. By way of prospectus, they invite the public to purchase shares. Prospectus. This is the advertisement. Published by the public company by inviting the public to purchase shares. So it is named as prospectus. Right. Now, when we consider the prospectus, right? this public company must mention their objects in the prospectus. That is the compulsory requirement. In regard to the provisions related to prospectus, companies access, right? Some information and reports to be mentioned in the prospectus. Auditors reports, accountant reports. So these are the reports to be mentioned in the prospectus. And not only that, some information also to be mentioned in the prospectus. One, right? Information means the objects of the company. Objects of the company. So even in the articles of association, this company is not mentioned the objects, but they have to mention their objects in the prospectus. So we can identify indirectly, right? They have to persuade them to mention their objects in the prospectus. Understood? Right. So they need not to mention their objects in the articles, but they have to mention the objects of the company. The prospectus. Why actually we have mentioned the objects in the prospectus? Otherwise, how public can make a decision whether investing in this company or not? For investment, right? So they have to mention what is the object of the company, manufacturing goods, in the investor, right? For prospective shareholder, prospective shareholder is future shareholder, right? They will be satisfied. This company has a profitable business. They will invest money in the shares of the company. So in order to get that knowledge, right? Then the company must measure their objects in the prospectus. Right? Then actually, like it's a company limited by Galle, public company, indirectly they have to mention their objects. Like, therefore, we can identify, it may set out objects. May set out objects that is mentioned, right? Avoid from mentioning. That is right purely applicable to this type of companies, private companies. Private companies. If it is a private company, they need not to mention their objects in the article, so they are not permitted to, right? They are not permitted to invite the public to purchase shares. They cannot issue shares to public. Therefore, the prospectus, that concept is not related to public companies. Therefore, indirectly, right, or directly, right, they need not to mention their objects in this, right? They need not to mention their objects, right? The article so in the base it out, it is right with regard to the private companies, only with regard to private companies. Lanka there, Manjana Kotas. Prospectus, ini kemudian yang kita pilih, ikadah dan saya mengenai itu masalah kenapa? Ada ini. Tenders market jadi
contact number
So this is regarding object clause of the company. Right? Now, section 13 says the company may set out its object. Right? So it is basically this rule is applicable with the private company because it is a company limited and guarantee shall specify the objects. Public companies, they have to mention their objects in the prospectus. Then thereafter, now according to this company, right, the object of the company is manufacturing goods. Manufacturing goods. Object of the company is manufacturing goods. Manufacturing and selling goods. So from this company engage into a contract for manufacturing and selling goods or any other transaction. Right? Any other transaction beyond the objects. Right? Now then we have to consider about the legality of this type of transactions. Right? According to the articles, object is mentioned. Right? As manufacturing goods. If the company engage into any other transaction beyond this object, then what is the legal effect of that transaction? Right? That is the next issue. Right? Now, here we have to consider common law as well as the Companies Act. Right? Common law. Common law and the Companies Act. Companies Act. Right. There are two positions, right? One is under common law and Companies Act. Common law means common this when we consider the common law, right? Actually, it has different types of meanings, right? Several meanings. One is now when we consider the one aspect is the law which is applicable to most of the people in the society. So in that sense, in Sri Lanka, common law is common touch. Right? But here, common law means case laws, according to the case laws. I think I have discussed this. But the building of way of incorporation, common law concepts like Companies Act. So here, common law means according to the case laws. Case laws. Right? Case laws. Right? And this is the statute. With regard to the companies, there is Companies Act. Number 7 of 2007. Right? So we have to consider the prevailing statutory law. Right, and the common law. Now, when we consider the common law, right, we can identify a particular case as the railway company, right? That Ricky versus Ashbury Railway Company. Case in this company, in this case, court held, right? If the company engaged in the contract beyond its objects, right? Then that contract, here, according to the objects of this company, right? Manufacturing and selling goods. Suppose the company engaged into a contract for manufacturing and selling goods, then this contract could be treated as void contract. Void. Right? It becomes void. Void contract. Right? Void contract. Void means there are three types of contracts we have discussed: void, voidable, and unalienable. Void means invalid from the beginning. Right? The contract is invalid from the beginning. Suppose the parties engaging in the contract 1st of January, from the beginning. From 1st of January, no valid contract between the parties. Right? So according to common law, right, this type of contracts are treated as void contract. Therefore, if it is a contract is void, or we can say null and void. Another means nullity. Null means nullity. Nullity means no value. No value. Right? Null and void. Nullity. Nullity means no value. Therefore, it is equal to no contract between the parties. Right? Void means no contract. Then if there is no contract, no party can seek any relief in the court of law. Right? So, suppose the company engaged into contract with another party, right? With another party, right? For manufacturing goods. And after engaging into this contract, suppose one party to the contract has violated the terms of the contract. Then as the innocent party, company or the other party cannot bring an action by seeking a relief in the court of law. By damages, so there are several remedies available to the innocent party. Right? If the party to the contract has violated contract, like under breach of contract, innocent party can seek several remedies, release, right? Like damages. But if it is a void contract, then no party can seek any relief in the court of, because it is invalid from the beginning. Understand? That is the concept recognized by common law, right? Case laws. Right? Actually, in this case, court discuss about the validity of this type of contract by introducing a concept. That is, now suppose the company engage into a contract beyond its objects. Then that type of contracts are named as ultra vires transactions. Right? Ultra vires. Ultra vires transactions. Ultra vires transaction. Right. All the ultra vires actually this concept is ultra vires. This ultra vires beyond the objects. Ultra vires and intra vires. Opposite is intra vires. Intra vires. That is within the objects. Intra vires. Within the objects. Right? It is vertical. These transactions are valid. If the transaction is beyond the objects, then these transactions are named as ultra vires transaction. Beyond the objects, ultra vires. Right? Ultra vires transactions are void transactions. Right? Therefore, no party can desire any relief when we quote unquote. No party can see any relief like damages if it is a ultra virus transaction. UV transaction here, like ultra virus. UV transactions, right? Ultra virus transaction. Actually, why this ultra virus concept introduced in this tricky versus actually Galle company limited? Actually, their main business is their object is manufacturing for that railway component, caravans, right? However, the company engaged into contract with another party to lay the railway line. In court, this transaction is ultra virus transaction. Right? No party can seek any relief in the court of law. Even if the contract is violated, no party can claim damages because it is ultra virus, therefore it is void contract. Right? In case of void contract, no party can seek any relief. Right? Why actually this concept is introduced by the higher courts? The common law, these are the decisions of the higher courts. Common law is decisions of the higher courts. Judgments given by the higher courts. Srilanka, Supreme Court and Court of Appeal. They are treated as higher courts. These are the decisions of higher courts. Why this concept is introduced? Take a name again, no taking it. Take a name. Why actually the ultra virus concept is recognized? Actually, this concept is recognized in order to give some protection to shareholders and creditors. In order to protect, give some protection to, right? Protect shareholders and creditors. In order to protect the shareholders and creditors. This concept is introduced. Why? Right? Why? Now, as I mentioned, suppose a prospective shareholder, before investing in the shares, he must consider about the objects of the company. Maybe mentioned in the article, so the prospectus. Then, after considering the objects of the company, if he is satisfied that the company has profitable business, then he will invest. Then after investing money in the shares of the company can utilize money only for that purpose. Only for that object. Company cannot pay out the money, right? Or utilize the money for other transactions which are not permitted by the object laws. Right? Therefore, money invested by the investor is utilized only for the objects. Right? Then company can, this will say, builds a profitable business with that belief the investor has invested money. Then, right, company can make profits. Thereafter, right, shareholders can receive dividends. The protection is given to the shareholders. And creditors, right? Another aspect is creditors, give some protection to creditors. That is, before granting a loan to the company by the creditor, creditor must be satisfied whether the company has a profitable business. Then how creditor can assess that whether the business of the company is profitable or not by considering the objects, main business of the company. It is manufacturing goods. Then the creditor is satisfied, yes, this company has a profitable business. Then grant a loan to the company. The company must utilize the money only for that, right, objects. right? Company cannot utilize or use this money for other purposes, right? Then the protection is given to creditor. Then company can make the profit. Then creditor can recover the loan capital with the relevant interest. The protection is given to the creditors. And so in order to protect the shareholders and creditors in this case, right? Ricky versus Ashwell Railway Company, that court has introduced this concept as ultra-wise concept. Right? So that is beyond the objects of the company, those are going transactions. Company cannot engage into that type of transactions. Company has to utilize money only for the objects which are right permitted by the object laws. And then ultimately the protection is given to shareholders and creditors. That's the term, right? That is the real necessity, right? For these shareholders and creditors, right? Because of the right protected the court here. These transactions are going ultra. It is an ultra virus transaction. It is going transaction. Right. That is under common law. So under common law, ultra virus transaction that is beyond the object laws, right? Beyond the object laws. Transaction is beyond the objects. Then they are ultra virus transactions. They are void contracts. Okay, no party can seek relief with the court of law. Right? Then we have to consider about the Companies Act. Companies Act. Right? When we consider the possession under Companies Act, possession under Companies Act, right? We have to consider two sections. Very important, right? It is the possession under Companies Act, two sections. They are section 17 subsection 1 and section 17 subsection very important. According to Companies Act, right, we can consider the status of the ultra virus transactions according to these two sections. Section 17, subsection 1 and subsection 2. Right? Section 17(1), it says, if the objects are mentioned in the articles, objects mentioned in the article, there is a object clause. The company and directors.
A business organization that sells good.
Company and directors, right, must engage into transactions which are permitted by the object clause. Right? In other words, ultra virus rule. Section 17, subsection 1, it has recognized the concept ultra virus rule. Right? Company and the directors must engage into contracts which are permitted by the object law. Permitted by the object laws. That's permitted by the object laws. In simple terms, we can say ultra-virus rule is recognized. Right? Ultra-virus rule, according to the ultra-virus rule, company cannot go beyond the object. Same concept recognized under section 17. Right? Recognize the ultra-virus rule. However, 17.2, right? It says power and capacity of the company. Power and capacity of the company cannot be restricted by its object clause. Cannot be restricted. Right? Power and capacity. Power and capacity of the company cannot be restricted by its object clause. Cannot be limited. Cannot be limited. Power and capacity of the company cannot be limited by its object clause. Right? Therefore, all the transactions, that is the word you see, all the transactions are valid. All the transactions. Right? All the transactions are valid. Valid and inclusive. So all the transactions means ultra-virus and intra-virus both. Right? UV, right? And intra-virus, ID. All the transactions are valid. Right. All the transactions are valid. Ultra-virus and intra-virus. Intra-virus, there's no argument. That is within the objects. They are right. Already valid. But here it says all the transactions are valid and enforceable. That is section 17 subsection. Right. Right. Then can we decide according to section 17.2 ultra-virus rule is removed by the company side. Ultra-virus consent, ultra-virus transaction, that consent is removed or eliminated by the company side. Either of the theme. That would be if you take a is eliminated by ultra-virus transaction. Then I go to Kaparan to the directly. So, the other section. Right? Actually, it is not removed. It is not removed. Ultra-virus rule is accepted by the company. Right? It is not removed. Eliminated by Antinomian section 17.2. Ultra-virus rule is eliminated by section 17.2. Actually, it is not eliminated. It is not removed. Right? It is not removed. Right? Now, here it says all the transactions are valid. But, right, there are two effects of ultra-virus transaction. There are two effects. Right? Subject to two effects. Right? Subject to two effects. Right? All the transactions are there. Right? All the transactions are valid. Right? Now here it says power, right? Power and capacity of a company cannot be restricted by its objectives. Right? Cannot be limited. Power, capacity cannot be limited by its objectives. Therefore, all the transactions are valid. Ultra virus, intra virus, all are valid and enforceable. But there are two effects of ultra virus transaction. Yes. There are two effects of ultra virus transaction. Right? Therefore, actually, we can, because of these effects, we can identify actually ultra virus rule is recognized. It is not 100% removed by the section 17 subsection 2 of the companies. Not 100%. Right? Two effects. One effect is before engaging into ultra virus transaction. Before engaging into ultra virus transaction. Before the transaction, UV transaction. Before. And the second effect is after the UV transaction. After the UV transaction. One is before engaging into ultra virus transaction, and the second effect is after engaging into ultra virus transaction. Right. We can consider the first one. Before engaging into ultra virus transaction, that is, suppose the company is going to, it refers to future. Company is going to engage into a transaction which is beyond the objects of the company. Right? Transaction is beyond the objects of the company. Suppose in this company, my example, the object is manufacturing goods. Suppose the company is going to engage into a contract for manufacturing goods. Then any shareholder or director, right? Shareholder or director can file an action against the company. Shareholder or director can bring an action against the company to prevent the company from engaging into this ultra virus transaction. They can bring an action. Therefore, actually, we can identify this concept is not written. That's why this right is given to directors and shareholders. Before engaging into ultra virus transaction, suppose this company, they are going to engage into contract for manufacturing goods. Shareholder or right, director of the company can bring an action in order to prevent the company from engaging into this ultra virus transaction. Right? So prevent the company. So this type of actions are named as injunctions. Injunction. The one relief available to the aggrieved party. Right? An injunction. By an action, by seeking an injunction. Injunction means corporate law. Right? Injunction here again. An order of the court preventing a person. Now here the company person is the legal person company. Right, preventing a person from doing an act. Right, preventing a person from doing an act. An act. Now the company is going to engage into a contract. Then ultra virus transaction. Then shareholder or director can prevent the company from engaging into this transaction. Injunction. Commonly we may, right? We can give common name to this type of actions. Injunction. That is injunction. Prevention node. Again, තහනමක් කරනවා කියන්නේ තහනම් කරන්නේ. යම් ක්‍රියාවක් කරන එක නවත්තන. කියලා හිතුවේ ක්‍රියාවක්. වක්හරි. Now, this is a violation of the articles of association. Therefore, it is illegal. This is not comply with the articles of association. If the company is going to engage into a transaction by violating the Companies Act or the articles, then shareholder or director can bring an action not to prevent the company from engaging into ultra-virus. Here, this is ultra-virus transaction. So, shareholder or director bring an action not to prevent the company from engaging into this transaction. There is violation of the articles of association. It's the fundamental law of the company. Because basically, we can identify two laws, right? Apply to the company. One is the Companies Act, the articles of association. Right? There is the constitution of the company. That constitution can be article fundamental law. So it is a company. The fundamental laws, there are two laws applicable. Right? The one is Companies Act and the articles of association. So if the company is going to violate the provisions of the articles of association, so this right really available to the shareholders and directors. Right. However, this is before engaging into ultra-virus transaction. After engaging into ultra-virus transaction, nothing to prevent. යමක් වුණාට පස්සේ ආයි නවත්තන්න දෙයක් නෑ. වෙන්න කලින් තමයි මේක කරගන්නේ. Right? Nothing to prevent. If the company already engaged into the contract, nothing to prevent. Then that is, we have to consider what is the relief available after the ultra-virus transaction. That is under second effect. You can consider. Understood now? If the company, before engaging into ultra-virus transaction, right? Before engaging into ultra-virus transaction, shareholder or director can bring an action in order to prevent the company from engaging into ultra-virus transaction. Injunction. You make this type of actions as injunction. Prevention or right? Or can prevent the company from engaging into this, like unlawful, like illegal transaction. That is, like before engaging into ultra-virus transaction. Then, after engaging into ultra-virus transaction, shareholders or directors cannot file an action. Cannot file an action against the company. Only relief is like introduced under Companies Act, that is right after engaging into ultra-virus transaction. After engaging into ultra-virus transaction, right? If the company suffers any loss, this is after. Company suffers any loss by this ultra-virus transaction. Now the object is manufacturing books. Company engaged into contract with another party for manufacturing goods. By this transaction, after engaging into this transaction, suppose the company suffers any loss. If company suffers any loss after engaging into this ultra-virus transaction, then the directors, right? They are managing the company. Directors, they are making the decision and engaging into this transaction. Therefore, directors are personally responsible to compensate the company. Directors. They are the persons who are managing the company. Directors are personally responsible. Personally responsible. Pay damages to the company. Right. That is after engaging into the ultra-virus transaction. Then what happens? Now, if the company suffers any loss, then directors must pay or compensate the company. Compensate the company. That liability goes to directors. Then it is not affected to who? Shareholders and creditors. Right? Understood? Why this ultra-virus rule is introduced? In order to give protection to shareholders and creditors. Right? If the company suffers loss, then shareholders cannot receive dividends. Creditors cannot recover money along with the interest. Therefore, in order to protect their rights, ultra-virus rule is introduced. But here what happens? After engaging into ultra-virus transaction, if the company suffers a loss, directors are responsible to pay damages to the company. Therefore, it is not affected to shareholders and creditors. Right? The protection, they are already protected because the responsibility goes to directors. Person is responsible to pay damages to the company. Understood? So that is after engaging into ultra-virus transaction. Right now, suppose the company suffers any loss, directors are responsible. If the company gain the profit, then what happens? Profit. By this ultra-virus transaction. Okay. The company makes a profit by this ultra-virus transaction. Right? Then actually it is not against the shareholders or creditors. Right? Right? No harm to the shareholders and creditors. In order to protect their rights, right? This rule is important. So the company is able to make profit by this ultra-virus transaction. There's no any legal effect. There's no any legal effect. So the choice is given to who? By section 17(2), choice is given to the directors. If they wish, even though this is ultra-virus rule, company can make profit, they can. The freedom is given to the directors to engage into that transaction. And only thing is company must be able to make profit. Otherwise, they are personally responsible. The choice is given to board of directors. They can decide that. Right? They can decide. Right? So that is the change done in this Companies Act according to section 17. But actually, when we considering these, right, section, legal effects, before and after, the legal effects of ultra-virus transaction, we can't say this ultra-virus rule is removed. It's not eliminated. It is accepted. Right? But only thing is before engaging into, we can identify that. Right? It is not removed because before engaging into ultra-virus transaction, shareholders and directors can prevent the company. They can bring an action against the company, prevent the company from engaging in this ultra-virus transaction. And after engaging into ultra-virus transaction, if the company makes, suffers any loss, the directors are personally responsible. If the company makes profit, because we can no any legal effect. Right? No harm to the shareholders and creditors. Company able to make the profit by this ultra-virus transaction. Right? Freedom is given to board of directors. They have to decide. It is up to them. Right? They can decide that whether engage into this type of transaction or not. It's up to the board of directors. Right? So that is the thing. That is like a decision making. You can do this thing and make, if they are able to make profit, then it's okay. There's no any legal effect. But only thing is stuff. The company suffers loss. Directors are personally responsible to compensate it. Understood? Right? Section 17 and So section 17, subsection 1 and subsection 2. Right? That is about the articles of association. Right?